Hello and welcome to the Bristows Patent Case Review of the year, for the year 2019. My name's Dominic Adair, I'm a partner at Bristows, and I'm joined by Katie Cambrook and Naomi Hazenberg, who are senior associates at the firm. We're bringing this presentation to you by webinar for the first time ever. We're keen to hear your feedback on that, so please do email us after you've seen the presentation. You'll find our email addresses on the final slide of this presentation, and we're keen to have your comments and questions. The agenda for the presentation is the same as it always is. So we are going to start with a look at what's changed in the court system over the past 12 months. Then I'll say a few words about statistics, and finally we'll do a top 10 countdown of the top cases of 2019, which is a purely personal selection, and Naomi and Katie will alternate that presentation. So a few words from me first on the court system, and I'll do this by reference to looking at the Patents Judiciary over the course of the year. So the faces on the slide are the judges with whom we're most familiar in patents cases. And we'll start by looking in the lower left part of the slide at the High Court Patents Court. So Mr. Justice Arnold was promoted to the Court of Appeal. He's now Lord Justice Arnold. That happened in around October last year. And to the great sadness of all of the profession, in July earlier that year, we lost Mr. Justice Henry Carr to ill health. Eyes up now to the Supreme Court, and you will see that Lord Justice Sales was promoted to Lord Sales after a not very long stint in the Court of Appeal. And to finish the picture with the IPEC, His Honour Judge Hakon, as well as being the presiding judge in the IPEC, was rather busy hearing Patents Court cases as a Deputy High Court Judge, and we'll say a bit more about that shortly. So let's now move on to look at some statistics. A return to the high numbers of decisions seen previously. So we had a record-breaking 86 decisions across the year. That's everything, interim decisions and cost decisions, as well as decisions on the merits. And a return to form there because the numbers had dipped a little bit in recent years. 20 of those decisions were first instance judgments on the merits, 14 from the Patents Court, and 10 appeals were heard during 2019, 2 of which came from the Supreme Court. We always say that life sciences and telecoms cases dominate. That's particularly so on the telecoms cases in 2019 with the dominance of FRAND litigation. But let's just look at the output of the courts. You'll see 2 notable points, the Supreme Court being a little bit busier with those 2 cases, but also an uptick in output from the IPEC, which had waned a little bit in 2018, but the highest number of patents cases from the IPEC in 2019 for 6 years, explaining why Richard Hakon was a busy man in 2019. And that's demonstrated very clearly by this slide, which if you look at the bottom shows him to have heard 19 cases in total, far more than any other judge, and Mr. Justice Arnold, the second busiest judge, with 13 cases. You'll see we've indicated with an asterisk the High Court, Patents Court judges, and the 3 judges who hear technical cases are indicated with an orange asterisk. What this slide shows is a high reliance on deputy judges sitting in the Patents Court as well as the regular Patents Court judges. So let's now look at outcomes. How did patentees get on in 2019? Well, validity was pretty much on trend at a little under 50% of patents held valid, and infringement also more or less on trend, with patents being held infringed in around 70% of cases. I thought it might be just useful to dwell briefly on those infringement statistics. I mean, infringement has always been a high number in the UK court system, and I think it will remain high because we now have the doctrine of equivalence. So here is a brief glance at all the cases in which doctrine of equivalence has been heard so far. It's about a dozen or so since the doctrine came in with Actavis and Lilly, the pemetrexed case in July 2017. And in every case, infringement was found. So you'll see that 2 cases there are coloured orange. Infringement wasn't found under the doctrine of equivalence in those 2 cases, but it was found under normal interpretation. So it's infringement every time so far under the doctrine. But look at the far left column, sorry, the far right column. The patent very often has not been held valid in these cases, so the decision is given on an obiter basis. Okay, just to finish from me on the outcomes, how did the individual grounds of challenge get on? You'll see that novelty was pleaded 4 times and was successful 4 times, contrasting with obviousness, which was pleaded 14 times and successful only 6 times, or 43% of the time. Insufficiency is commonly pleaded now following the rise of plausibility, 6 counts of pleading, but only 33% success rate on that. And added matter, 50% success rate, which is about normal for that ground of invalidity. So having said that, I'm going to hand over now to Naomi and Katie to take you through the top 10, and I will leave you in their capable hands.
That's great. Thanks, Dom. Okay, so the first of our cases in our top 10 is Conversant and Huawei. And unusually for us, we've included a case about costs in our top 10. Mr. Justice Arnold heard the first of the draft technical trials in the Conversant litigation against Huawei and ZTE. The patent was found to be invalid, and it was common ground that the defendants were the overall winners. The judge acknowledged that successfully defending a claim for infringement on any basis means that a defendant achieves a significant commercial result, as they avoid financial remedies and an injunction. However, when it came to costs, the story wasn't quite so clear-cut. He said the defendants had won on an argument that the patent was invalid due to matter being added during prosecution. However, there was a large number of other points running the case, including numerous construction issues, 2 allegations of obviousness, some insufficiency attacks, and further added matter attacks. The defendants had lost on the rest of these points, so what should happen with costs? It's fair to say, I think, that Mr. Justice Arnold was not very happy. The defendants had run 20 points and lost on 19. He noted that they'd presented their case in a way which was unsatisfactory and unreasonable. The judge described the amendment during prosecution as being one that plainly added matter. The claimants didn't try to defend the claim as granted, but sought to remedy it with a further amendment. The judge commented that this was a narrow, self-contained, discrete point, which was a point of law and didn't involve any expert evidence and could have been decided in half a day. He noted that the defendants' arguments that they should recover all of their costs was preposterous, and a return to the bad old days of the winner taking all the costs regardless of the nuance on how many points they'd actually won on. He said that cost recovery should reflect the success of the parties, including looking at all the arguments that were run at trial. He said there was no question of the defendants recovering all their costs. He rejected all of the defendants' arguments. The judge was of the view that the added matter point was so clear that the defendants shouldn't have run any of their other points. However, he didn't penalise the claimants for bringing an infringement action on that patent. Apparently, he said to do so would have overlooked the fact that he'd given permission to appeal that point to the Court of Appeal. So he clearly did accept that there was a real prospect of success to overturn that added matter point on appeal. In the end, the defendants were ordered to pay 70% of the claimant's costs as a fair reflection of the overall degree of success of the parties. So, we've said this is an important case because we think it makes it significantly harder to advise clients on cost recovery in the UK. Do the winners really pay the losers' costs? We also think it's a salient reminder to litigants to really assess their case and focus on your very best points and be careful what points you run at trial. We also think it points to the judges being keen to encourage parties to push for legal, discrete points to be heard as preliminary issues at a much earlier date. In the Novartis and Dr. Reddy's case, Mr. Justice Burse offered to give judgment on an added matter invalidity attack, having only looked at it on a summary basis. In the end, he didn't do so, but maybe it's an indication that the judges are willing to do this if it clears the very overloaded court diary of some of the listed hefty and long trials.
So, in at number 9, we have Pfizer and Roche, and the first of our life sciences cases. And what were the facts of this case? So here, Pfizer had sought an arrow declaration in relation to 3 patents held by Roche in relation to the monoclonal antibody bevacizumab used in the treatment of certain types of cancer. Pfizer had obtained a so-called skinny label marketing authorization in the UK and planned to launch its product in June 2020 on expiry of the compound pediatric extension. However, Pfizer wanted commercial certainty in relation to certain pending patent applications to enable it to obtain a full label marketing authorization and launch its product on that basis. Pfizer was wishing to make its product in Belgium and import it into the UK, so there was an issue in this case that related to sales of the product in the UK, but Pfizer was also keen to have a UK judgment which may be influential in the Belgian courts in any infringement or validity actions there. As a result, both sides called Belgian lawyers to give expert evidence on whether the Belgian court would take into account a UK decision. And as such, the spin-off value of any judgment in the UK was an important point in this case. Roche took a very light touch to this litigation and engaged as little as possible. Shortly after the pleadings were served on them, they de-designated the UK from all relevant pending patent applications, and further, they did not take part really in the case. They didn't put forward any technical evidence, nor engage with the validity case, including not cross-examining any of Pfizer's witnesses. Pfizer had said that this was an attempt to shield the patents from scrutiny, but Roche said it really underlined that it wasn't appropriate for a technical decision to be given on the merits. So what happened? Burst was taken to several authorities on the court's discretion in granting arrow relief, noting that it was in the court's discretion to grant such relief, but justice to the claimant and the defendant should be taken into account, as well as whether such a declaration would serve a useful purpose, and whether there was any special reason why it should not be granted. Of particular importance in this case was considering the Fujifilm case, which had come a few years previously, and the judgment of Henry Carr in that case. In the Fujifilm case, there was also substantial spin-off value for an arrow declaration, and it would be useful to use it in jurisdictions outside the UK. Similarly to this case, the UK rights in issue had been de-designated, and in the Fujifilm case, an arrow declaration had been granted. However, Burst distinguished the current Pfizer and Roche case from the Fujifilm case, saying that in Fujifilm there was still some uncertainty in the UK in relation to a complicated set of undertakings that were being offered, and therefore the situation was different to the current case where there was no commercial uncertainty. Therefore, no arrow was granted in this case. There was no useful purpose for that to be granted in the UK. Really, the only interest was the spin-off value for the Belgian proceedings, and that was essentially forum shopping, which wasn't to be allowed. In the judgment, Burst did consider a couple of other points, which I'll just mention briefly, and that was that in his assessment, there was a strong case for a Gillette defence, but he didn't provide any reasons in relation to that, as he said to do so would be to effectively do what he said he would not do in granting the arrow declaration. He also held that, or he inferred that Roche's motives were to shield its patents when it de-designated them from the UK proceeding, from the UK on receipt of the pleadings from Pfizer. And finally, there was a point on the commercial value. As I said, Pfizer wanted some commercial certainty as to whether or not they could obtain a full label marketing authorization. And that had been alleged by Roche to be a lawyer's point and not really a point of commercial value for Pfizer. But the judge found in Pfizer's favour in relation to that, and also said that a judgment to export to other countries would also have some commercial value. So why is it important? It shows that the spin-off value of an arrow declaration is not enough for that to be granted in the UK proceedings. There has to be some real commercial uncertainty in the UK to have an arrow granted. There's a question as to what happens next for arrow declarations. Is it possible for patentees to avoid them by de-designating the UK and taking this minimal participation approach that Roche did in these proceedings? So we wait to see what happens next for arrow declarations.
Great, thank you, Katie. Okay, so on to our next case in the top 10, which is Conversant Apple. And in this case, Mr. Justice Burse heard a case where Conversant had sued Apple on one of its non-standard essential patents. It was a patent that concerned the user interface experience and specifically an application summary menu of the common functions or stored data. This was asserted against two of the aspects of Apple's iOS. Apple's counterclaim included arguments on obviousness over two pieces of prior art, an aggrevo argument, and points on added matter. Ultimately, the patent was found to be invalid over an early IBM cellular phone. However, the key point that I want to pull out of this case is an argument that ensued regarding the effect a claim amendment can have on the identity of the skilled person. So, this dispute stemmed from the amendment which I've showed on the slide to limit the claim from being concerned with a general computing device to a smartphone. The patent describes the field of invention as relating to a computer device and defines that to include any kind of device that can process or display information. It also is said to have a specific application to a mobile telephone, which again it defines very widely to include what we would normally think of a mobile phone, but also PDAs, smartphones, wireless information devices. At the time, a mobile was a 2G device like the Nokia 3310 with a very small screen, and it was clear from the detailed description in the patent that the detailed description of the invention and the figures that the problem is focused on one that arises in this type of small screen device. Mr. Justice Burse commented that it could be seen that the actual invention was addressed to this type of device, but it was subsequently recognised that it might have wider potential to computer devices generally. However, now that validity was an issue, a wide claim was going to prove troublesome. Conversant submitted that the skilled person was focused on user interface designed specifically for conventional mobile phones, and Apple, on the other hand, argued that the skilled person had a wider experience of computer devices generally. The judge commented that the skilled person was a legal construct, but pursuant to the Schlumberger case, you have to keep an eye on reality. He said the problem with Apple's approach was that it focused on the field of invention identified in the patent, but having done so, the notional skilled person could end up working on products like a PDA that by virtue of the amendment was no longer covered by the claim. He said the skilled person has a practical interest in the subject matter of the invention is defined by the claims, and as a result, the skilled person can change because of a post-grant amendment. He found, therefore, the skilled person was somebody with a practical interest in smartphones. So, we've said that this is important because it's important to see that there is a principle that the skilled person can change if the claim is amended. It might be rare, but it can happen. We think it's a crucial factor to consider when you're choosing an expert, especially in this jurisdiction where expert evidence is so key. You could easily end up with your whole expert evidence being discarded as a result of an amendment late in the game. It's possibly easier for a patentee to do this, so defendants will have to think carefully about potential amendments throughout the case as they go on working with their experts.
So next, we take a look at the case of Emson and Hozelock. The facts of that case were that Emson held a UK and European patent for an expandable hose assembly. Emson brought proceedings against Hozelock, alleging that the Superhose 1 and Superhose 2 infringed those patents. This is not the first time that these patents have been asserted or their validity tested. Some amongst you may recall that back in 2013, Mr. Justice Burse found that another competitor product, the flexible hose, infringed these patents, and indeed that the patents were valid over two pieces of prior art, and that decision was upheld by the Court of Appeal. In this case, Hozelock counterclaimed for invalidity and included the same two documents that were before Burse in the 2013 decision. One of those, namely a patent application called McDonald for a self-elongating oxygen hose for stowable aviation crew oxygen mask, is of particular importance, and we'll come back to that. The case on invalidity also raised an interesting point about lack of inventive step over prior use. As a bit of background, the inventor, Mr. Baradi, was living in a house in a small cul-de-sac in Florida, and in 2011 he decided to make this flexible garden hose. Over a period of 3 months, he attempted to make the hose both in his house and his garden, and his efforts were filmed by his wife. At the beginning of November that year, he had a prototype, and the very next day from finding his prototype, he filed a patent application in the US. And the question was, while he worked in his garden, was that a public prior use where his garden could be seen from the road? So what happened? Perhaps not the decision that many would have expected. The patents were held invalid over a document that was previously considered in the 2013 case, that McDonald prior art for oxygen hoses for aviation crew. And the reason for that was that in this case, the skilled person was held to be a general hose designer and not just a garden hose designer. And so that piece of prior art was relevant and taken into account. That has meant that the novel point of law on the prior use is obiter, but it's still interesting to take a look at. So in looking at that prior use arguments, when considering them, Nucci had to give credence to whether development had taken place over several months. The question was whether the skilled person could combine those disclosures into one. Obviously, it's a well-known point that mosaicing of prior art is not permitted generally under English law, the exception being where there's a cross-reference or a motivation to do so. Here, Nucci held that the different work on different days couldn't be mosaiced. Indeed, on some days, the view from the road it was observed by the judge would be that it just looked like a man using a hose. Given such a disclosure, the skilled person would not have had any motivation to come and spy on Mr. Baradi on other days, and therefore it wouldn't have been clear to the skilled person watching the inventor that he was testing a prototype that he had made the previous day. In case he was wrong on that and the disclosures could be mosaiced, the judge considered that circumstance as well. However, again, he found that the information would not have been made available to the public when no member of the public could have accessed it. On the facts of the inventor's evidence, he said that had he seen anybody watching him, he would have packed up his work and gone indoors. There are a couple of points of interest on infringement by equivalence and also mention of a Formstein defense. I won't go into those, but they will be touched upon in other cases in our top 10. So why is this case important? It seems that Mr. Justice Nucci has introduced a new concept into the test for public disclosure that's potentially in conflict with cases like Windsurfer and Milliken Mats that were previously the law, where in those cases there had only been a requirement of potentiality for a member of the public to see or hear the disclosure, whereas now Mr. Justice Nucci seems to have introduced a further criteria of subjectivity, and that bright line appears to have become blurred. The case is on appeal, due to be heard in June, so we'll watch this space and see what happens.
Okay, so our next case in the top 10 is another one from Mr. Justice Haycon, and it's the Technetix case. And in this case, Technetix sued Teleste for infringement of its patent, which related to cable tap units, which are the boxes at the end of your street that have lots of wires in. When a signal arrives at the street cabinet, it's much too high in strength for the ultimate end user devices. And those tap units have directional couplers to reduce the signal strength. The invention in this patent related to a removable coupler in the tap unit so that one can be selected by an engineer that can be used to select the required output signal level, and also meant that you could replace them or change the signal strength by only changing the directional coupler rather than previously changing the whole tap unit. Teleste's counterclaim included 2 pieces of prior art, and in fact, the judge found that the patent was invalid over both of these pieces of prior art for both lack of novelty and lack of invented step. He did, however, go on to consider the infringement case on an obiter basis. In their defense, Teleste had argued that if the products fell within the scope of the claim, it should be entitled to a defense if their product also lacked novelty or was an obvious modification over the prior art. So the judge went on to look at the possible availability of a Gillette defense in the post-Actavis world of equivalence. The judge summarised the pre-Actavis position from Merrill Dow and Gillette that it was possible to practice the prior art with any non-patentable variations without infringing, as having been a long-established basic principle of patent law in the UK. His Honour Judge Haycom commented that it would be surprising if the Supreme Court in Actavis had meant to abandon that principle without expressly saying so. He suggested that one way to reconcile Merrill Dow with the doctrine of equivalence was that if a product or process infringed by equivalence, but would also have lacked novelty or inventive step over the prior art, there should be no infringement. He noted that such a defence exists under German law, and it was set out in the Federal Supreme Court case of Formstein. It also exists in Dutch law and US law, and it's neatly summed up in the US case of We Care, where they said a determination of infringement on the basis of the doctrine of equivalence cannot be made in a vacuum. The prior art must be examined to assure that the range of equivalence asserted by the patent holder didn't encroach upon the prior art. He noted that this defence might be introduced in the future by the Court of Appeal or the Supreme Court. The judge went on to consider the facts on the basis that such a defence does exist. He noted that the tap unit being considered didn't infringe on a normal construction because two of the features were missing. However, when assessing it on the basis of the doctrine of equivalence, he noted that it exploited the inventive concept in the same way by allowing the directional coupler to be changed without disturbing the rest of the system. He said it would have been obvious that the same result was achieved in substantially the same way. The difference, which he said was having all the circuitry in the base unit, wasn't an essential requirement of the claim. And so in conclusion, he found that it would infringe by the doctrine of equivalence. He went on to show how a Formstein defence could provide a type of squeeze argument on this infringement case, the type we were familiar with under the old law. He noted that in a case where the inventive concept is relatively simple, like this one, the scope of the claim is broader, and so it's more likely that such a defence will apply. The judge agreed with the defendants that at the priority date, the skilled person would have thought it obvious to adapt the common general knowledge tap unit in a way that was like Teleste product. And so he found that if a Formstein defence did exist, then Teleste was entitled to it. So this is a non-binding decision, but it's interesting that it was possible that the Formstein defence was assessed by this judge, and so maybe an indication that the judiciary might be receptive to this type of argument, and maybe it's a return of the type of squeeze argument that we felt have been tricky since the Actavis decision. We're watching this case with interest. It's due to go up to the Court of Appeal this year, and so we'll see how that's dealt with there.
So next, we return to a life sciences or medical case, and we look at the case of Regen and Estar. And the facts of that case were Regen held a patent for a method of preparing a blood plasma enriched with platelets, platelet-rich plasma, or PRP, as it's referred to on the slide. Estar alleged to supply kits in the UK to prepare PRP according to the patented method. So the patent in issue claimed a process for the preparation of a cell composition comprising the steps of centrifuging whole blood in a separated tube, removing half of the platelet plasma from the top, and resuspending the remaining plasma with a buffy coat to produce this platelet-rich plasma. The claim was quite specific as to the type of tube and the centrifugal force to be used, and in particular, the claim also included a requirement for a 0.10 molar sodium citrate to be used. The inventive concept of the claim was said to reside in the resuspension step, which permits the preparation of the platelet-rich plasma from the whole blood only using a single centrifuge step. As a bit of background to the invention, PRP has been used by clinicians to promote wound healing, and it's also been used in diagnostics for quite some time. These are two quite distinct fields. The invention here is for the use in cosmetic surgery. For decades, machines had been used to make this platelet-rich plasma, and on the diagnostic side and the therapeutic side, different techniques had been used to obtain the PRP. In this case, Estar alleged the patent was invalid, and much of the judgment is given over to lack of novelty and lack of inventive step. So what happened? As I mentioned, quite a lot of the judgment was on this lack of novelty and lack of inventive step. So just to touch upon those, the lack of novelty was over a prior disclosure to some doctors in Japan, which was given by the patentee. There were several witnesses of fact that were important in making this decision and who were called. And unfortunately for the patentee, he was considered an unreliable witness in this case. In relation to the lack of inventive step arguments, interestingly, the patentee had made some arguments in relation to long felt want. The invention, as I said, the core of the invention was this single spin of the centrifuge to obtain material to make the plasma-rich protein. The technique had been used on the diagnostic side before, but had not been picked on the therapeutic side, and this was something which Regen had done. The judge said that while this evidence was considered, it was not held to overwhelm the other evidence which pointed towards a lack of inventive step, and so unfortunately for the patentee, the patent was held invalid. However, if the patent had been held valid, it would have been held to be infringed, and this is a case where the doctrine of equivalence has been looked at in relation to numerical limitations. You will recall I said that the patent included in the claim the requirement of a 0.10 molar solution of sodium citrate. There were several differences in the potentially infringing product, but one of those differences which was considered was in relation to the amount of sodium citrate that was used. The potentially infringing product had a 0.136 molar solution of sodium citrate. On the basis of the doctrine of equivalence, this was held to infringe, which is an interesting point. There were some additional arguments about reopening the trial on further evidence, but I won't go into those. So why is this case important? There are several things in the case that can be considered interesting to the reader. Different technical skilled teams were considered to be possible for inventive step and sufficiency. There was also an interesting discussion on the territorial limits of CGK, in that there has to be a certain level of understanding within the UK for something to be considered common general knowledge here. The knowledge can be imported from other countries, but it has to reach this particular level before it can be considered to be CGK here. There was also a question of combination of documents for the inventive step arguments. One of the documents relied upon was a series of web pages from a website. And so if you are particularly interested or come across a case like this, it's an interesting place to look at to see some detail on what needs to be included on a particular web page to enable it to be combined with another web page in terms of considering combinations for inventive step. The key point here, though, was the equivalence and the numerical claims that I mentioned, and this look at numerical claims through the doctrine of equivalence is no different to other claims. This case is also due to go on appeal, so it'll be one to watch this space again, and we'll see what the Court of Appeal has to say about it.
Okay, so the next one is the case of IPECOM and Xiaomi, and this confirms IPECOM's now infamous patent that had been previously asserted against Nokia and HTC in the past. In both cases there, it was held to be valid and essential to the UMTS standard by the Court of Appeal. So when Xiaomi launched in the UK, IPECOM started an infringement action on the same patent against Xiaomi's UMTS devices in late October 2019. However, the patent was due to expire in February 2020. So IPECOM was aware that any trial would not take place until after the expiry of the patent. At that stage, as there would no longer be any ongoing right, there would be no risk of an injunction following a finding of infringement. In SEP cases, as you're aware, it's at that point that the infringing implementer faces the election, choosing between submitting to an injunction or undertaking to enter a FRAND license. IPECOM knew that it would never reach this point. So asked Xiaomi at the start of the action to undertake to enter into a license on terms deemed to be found by the court if the patent was found to be valid, essential, and infringed. When Xiaomi refused to give this undertaking, IPECOM applied for a preliminary injunction. This was heard by His Honour Judge Haycom. So just to give a little bit of a background, the key argument for this preliminary injunction was based on the difference in scope between a forward-looking FRAND license and historic damages. A brief summary of the two is that although this is still to be confirmed or subject to the Supreme Court's decision, the Court of Appeal has found that it's able to set a forward-looking FRAND license that was global, portfolio-wide, as that was found to reflect realistic commercial negotiations between the types of parties. Such a FRAND license included a backwards release clause, so there was no separate basis for calculating damages for past infringement. Without a forward-looking FRAND license, a patentee is limited to historic damages. There hasn't been any binding decision on this, but in his Unwired Planet decision, Mr. Justice Burst made an obiter comment that damages should be calculated by applying a portfolio rate to UK sales only. It is, however, still very much an open question, and there are arguments that span the whole range of possible calculation, from single patent UK damages only to global portfolio-wide in the same as a FRAND license. It's worth noting that there has been a summary judgment decision dismissing a summary judgment application in the Phillips and Aces case by Mr. Justice Marcus Smith, but he doesn't give an answer to this question. So, IPECOM submitted that the effect of the requested undertaking was to preserve the position. If the patent was found to be valid and infringed, Xiaomi would be bound to pay a FRAND rate eventually for its infringing activities. However, if the patent was invalid or not infringed, it wouldn't be bound to enter into a FRAND license. Without the undertaking in place, IPECOM submitted that Xiaomi would be able to constantly refuse to enter into a FRAND license because there was no injunctive relief available after the trial. The argument that IPECOM would suffer irreparable harm without a PI was focused on the lost opportunity to seek that global portfolio-wide FRAND license. As the patent would have expired, before any finding of infringement, Xiaomi could just refuse to enter the license, and there was no injunction to compel them to take the license. IPECOM said Xiaomi would argue for single patent UK-only damages, and IPECOM said that this was just a pure holdout, a way for Xiaomi to avoid paying fair compensation to the owner of a valid, essential, and infringed patent. These arguments were all rejected by the judge. He found that there was no lost opportunity. He said IPECOM had no right to force Xiaomi to enter into a license. That was the choice of an infringing party. Consequently, there was no right to any royalties from that license, so it didn't matter whether those hypothetical royalties would have been larger than the sum payable as damages. He didn't accept that there were any parallels between this case and, slight spoiler alert, the injunction granted by Mr. Justice Henry Carr in the TQ Delta decision. In that case, he said there had already been a finding of infringement that there was of a valid SEP against that party. And by contrast, here there was no starting presumption that IPECOM was entitled to an injunction. So we've included this because it's so rare to see a preliminary injunction application in an SEP case. It's interesting for those of us who have had to navigate the FRAND issues to see that it might have been possible to make an injunction compatible with a patentee's FRAND obligations. That was all rejected by His Honour Judge Haycom, but given the comments by Mr. Justice Burse in the IPECOM case against Vodafone, that there was no flaw in a very similar requested undertaking, and that the defendant was at risk of being characterised as an unwilling licensee for refusing to give it, it would be interesting to see if the same approach was taken by other judges. He also confirmed on a procedural basis, on a procedural note, that the American cyanamide test still applied to FRAND encumbered SEPs, and that although there was an outstanding jurisdiction challenge in this case, the court still had the ability to and the jurisdiction to grant interim relief.
And so we come to case number 3, and Actavis v Lilly and ICOS, and the first of our cases that was before the Supreme Court last year. So the facts of this case were that Lilly was the exclusive licensee of a dosage form patent for tadalafil for the treatment of sexual dysfunction. Tadalafil was a second-in-class medicine for this use, the first being sildenafil, or Viagra, as it's more commonly known. Viagra was marketed at doses of 25, 50, and 100 milligrams, and the efficacy was known to increase with the dose, but so did the side effects. Tadalafil had a more selective binding and so had less side effects. The cited prior art in this case referred to tadalafil and provided an example of a tablet with 50 milligrams. The claims of the patent in issue were for a dose of between 1 and 5 milligrams of tadalafil. Before Mr. Justice Burse in 2016, the generics had argued that it would have been obvious to carry out routine preclinical tests and a clinical trial program from the cited piece of prior art, and in doing so you would identify the dose in the patent. Such dose ranging studies are standard, and you would want to find the lowest effective dose. Lilly had argued that it wouldn't be obvious to try a dose that was so low. Mr. Justice Burse accepted that it would be entirely obvious, based on the prior art, to do the routine tests, but he would not have had a reasonable expectation that the 5 milligram dose would have been clinically relevant or would have had minimal side effects. The patent was therefore held valid and infringed in the High Court. The generics appealed, and in a judgment from Lord Justice Kitchen in November 2017, Mr. Justice Burse was reversed in no uncertain terms, saying that unfortunately Mr. Justice Burse had made an error of principle which allowed the Court of Appeal to consider an issue based on facts. Lord Justice Kitchen said it's very likely that the routine tests would have been carried out, and in doing so, a dose of 5 milligrams per day would have been found. When this was found, it would have been found to be safe and efficacious, and at that point, they would have arrived at the claimed invention. So what happened before the Supreme Court? The decision of the Court of Appeal was upheld, and the patent was held invalid for obviousness. The appellate court was justified in differing from the trial judge's view on obviousness if it was considered that the judge's finding was outside the bounds within which reasonable disagreement is possible. When considering which dose to be tested, Mr. Justice Burse had said it was highly likely that the lower doses, i.e. those claimed in the patent, would have been tested, but he did not appreciate the logical consequences of that decision, and that enabled it to be overturned. So why is it important? There's no real substantive change in law or practice as a result of this decision, but it does give a thorough review of the law of obviousness. In the judgment, there are 10 factors that are considered in relation to obviousness, including obvious to try, research routines, the cost and burden of research, nature of value judgments that are required by the skilled team, existence of multiple paths of research, the nature of the invention, and so on. So it's a good place to look at if you're wanting to see a good overview of the law of obviousness in the UK. It's also a reminder that the clear test in the UK is that's laid down in statute in relation to inventive step and in Section 3 of the Patents Act, and that any tests, the problem solution approach or the Pozzoli test, are said to be a gloss on top of that. There's also some interesting discussion on the role of foreign judgments. These are still considered to be important, but you shouldn't consider them without critically considering the judgment themselves. In this case, the different cases in different countries had been advanced on different evidence, which was tested differently and came to different findings. They were therefore of limited use in this case. There was also some concern after the Court of Appeal judgment in relation to dosage regime patents and patents that were the result of routine testing. The Supreme Court sought to allay those fears by saying that the Court of Appeal judgments were fact-specific assessment on the facts of this case, and they should not be construed as supporting any general idea that a product of well-established or routine inquiries cannot be patented.
Okay, so on to the trio of TQ Delta decision that had FRAND and SEP litigators gripped last year. So this is also reflective maybe of the fact that SEP practitioners has had to focus on issues relating to relief and jurisdiction just as much, if not more, than actual patent litigation. So a very quick gloss over the technical trial, which resulted in Mr. Justice Henry Carr finding that one of TQ Delta's patents was invalid, but that the other one was valid and essential to the relevant ITU standard. The patent only had 3 months left before expiry, so that led to some interesting arguments at the final order hearing, where Henry Carr had to decide whether or not to grant an injunction. Here we come back to the election that an implementer is faced with when it's found to be infringing a standard essential patent: be injuncted or give an unqualified undertaking to enter into a license on whatever term the courts deem to be RAND. In this case, we're talking about RAND rather than FRAND, as that's the obligation imposed by the ITU. However, there is no material difference between RAND and FRAND. ZyXEL's case sought to use RAND as a shield, i.e. it said it wanted to take a license on RAND terms if any of the patents were found to be valid and infringed. However, when TQ Delta sought confirmation of that position, ZyXEL started to wobble, and after a year of blowing hot and cold, ZyXEL confirmed that as the patent was going to expire so imminently, they didn't want a RAND license from TQ Delta. The judge was clearly unimpressed by this conduct, and without being asked to, he made a declaration that this was a case of holdout by ZyXEL. Having made that election, the judge had to decide whether they should be able to avoid being injuncted. ZyXEL argued that granting an injunction with only 3 months left to run on a patent would be disproportionate. That was rejected, as it would allow ZyXEL to benefit from its holdout and avoid any consequences of refusing to enter into the license. The judge commented that this would essentially have amounted to a compulsory license. The judge also refused to stay the injunction pending appeal. Although there was a suggestion that it would have caused inconvenience to the customers, there was no actual evidence put forward that showed prejudice to those customers. The judge refused permission to appeal the grant of the injunction, as the Court of Appeal had considered those principles in the Unwide Planet case. And Lord Justice Floyd also refused permission to appeal the grant and imposition of the injunction. And so, having been injuncted, ZyXEL decided to expressly waive any right that might have arisen from TQ Delta's RAND obligation in the UK. It then argued that as a result of this waiver and the injunction, the RAND inquiry, which had already been scheduled and listed, should be vacated. TQ Delta, on the other hand, started a new infringement action and sought to amend their current claim for declaratory relief to include a request for a declaration that ZyXEL were not willing licensees. At first instance, this came before Mr. Justice Burse, who was deeply sceptical about ZyXEL's behaviour and the effect of the waiver. In deciding that the new action wasn't an abuse, Mr. Justice Burse found that the action was justified given that there had been a very significant change in position by the defendants after they'd lost at trial. The judge held that the effect of the waiver wasn't clear, and there were a number of issues that were still plainly arguable. He found that a real and lively dispute as to the RAND terms still existed, and that therefore the RAND trial should go ahead. He said that this would include determining the effect of the waiver, which he said wasn't practical or realistic to do at the hearing before him. However, the Court of Appeal disagreed. Lord Justice Floyd started by stating that the court shouldn't grant declaratory relief where it would serve no useful purpose. The waiver, he said, changed the position and meant that a declaration determining the scope and terms of the license that TQ Delta had to offer the two ZyXEL defendants would no longer serve a useful purpose, as that license would never be deployed. The Court of Appeal also went on to determine the effect of the waiver. It said that it might not be possible to selectively claim the right to a RAND license. If that was global, it was arguable that it had to be taken on an all or nothing basis. However, it was possible to selectively say they don't want the UK license. Therefore, there was no basis for saying that the waiver was ineffective or invalid. It was noted that the Unwide Planet decision doesn't give SEP holders an independent right to have a determination of the RAND terms. That only arose as part of the question of relief. Lord Justice Floyd also rejected the arguments for a declaration that ZyXEL were not willing licensees. He said that wouldn't be useful for res judicata purposes. He found some quite serious problems with that point, Firstly, he noted there were no foreign proceedings either ongoing or in contemplation where that could be of use. There was no unified approach to how RAND or FRAND issues interact with patent infringement relief, or to the question of what constituted a willing licensee. Additionally, he said a declaration would equally be of no use if it was exported to a jurisdiction that didn't have a doctrine of res judicata or that didn't recognise foreign judgments. Furthermore, he said, if you had to look at whether ZyXEL were not willing global licensees, that would concern other ZyXEL companies that were not part of the UK case. He said it wouldn't be in line with the overriding objective to allow a trial for declaratory relief to go ahead that had no use, cost £4 million, and took up 10 days of court time. He concluded, therefore, that it would be far better for the issues to be decided by a foreign court as and when those issues arose. And he stated that to decide that here would be an exercise in jurisdictional imperialism. So why is that important? It's interesting, firstly, that Mr. Justice Henry Carr moved the timing of the election earlier than Mr. Justice Birth had it in Unwide Planet. There, it was only put to the defendants once the FRAN terms had been determined. That might be due to the particular circumstances of the pending expiry of the patent. However, it's worth noting that Mr. Justice Birth in the IPEC Vodafone case seemed to accept that it was possible to move the election even earlier to the start of the action. An injunction was granted. That's notable in itself in an SEP case. In refusing permission to appeal the grant of the injunction, Lord Justice Floyd noted that if a defendant had refused to enter into a RAND or FRAND license and wouldn't submit to the determination of those terms, there was no reason to treat the infringing implementer any different from any other defendant in any other type of patent case. It also maybe is an indication that judges are willing to make declarations about potential licensees holding out without a formal pleading. Following this case again, in the IPEC Vodafone case, Mr. Justice Birth commented there was a risk of the defendant being characterised as an unwilling licensee for refusing to give the undertaking, but he noted he didn't have to resolve it at that point. Also, it shows that following a finding of infringement, if a defendant chooses to submit to the injunction and exit the UK market, it can avoid RAND determination and potentially a global licence.
And so we reach our number one case, and it's Shanks and Unilever, a case that has been running probably for the longest of all of our cases that we've considered in our top 10. So as a bit of background, in the 1980s, Professor Shanks was employed by the research arm of Unilever, known as CRL. He was employed in a research capacity, and during the course of that employment, Professor Shanks was the sole inventor of the sensor technology that became known as electrochemical capillary fill devices. He actually created the invention at home using some slides from his daughter's microscope kit, hence the picture on this slide. However, the invention was actually made in the course of his employment, so belonged to his employer CRL. They eventually assigned those rights to Unilever for £100. In 1985, Unilever filed some patents that covered the technology, the electrochemical capillary fill devices, and those patents became known as the Shanks patents. Unilever itself didn't seek to develop any products on the basis of those patents, as Unilever's principal business lays in the manufacture and sale of household products, from which it generates billions in turnover. In the late 1990s, it became apparent that the electrochemical capillary fill devices technology could be incorporated into diabetes testing kits. Unilever didn't proactively attempt to exploit the patents in this area, but multiple companies did approach Unilever and seek licenses. Unilever entered into a total of 7 licenses and eventually also sold its patent rights. Ultimately, the value that the Shanks patents gave to Unilever was in the region of £24 million. So Professor Shanks applied for compensation under Section 40 of the Patents Act on the basis that the Shanks patents had been of outstanding benefit to his employer, CRL, having regard, amongst other things, the size and nature of the CRL undertaking, and as such, he was entitled to a fair share of that benefit. However, Professor Shanks' application was refused by the hearing officer at the UK IPO, on appeal to the High Court, and also at the Court of Appeal. He therefore sought an appeal to the Supreme Court on two issues. Firstly, what is an outstanding benefit? And secondly, how should a fair share of an outstanding benefit be assessed? So what happened? 13 years after he first made his claim, the Supreme Court overturned the lower court decisions and found in his favour. The Supreme Court held that the statutory test under Section 40 requires the benefit of the patents to be outstanding in the ordinary sense of the word, for example, exceptional or such as to stand out. In assessing the employer's undertaking, the Supreme Court made it clear that the commercial reality of the situation must be considered. Here, the Supreme Court found that the employer in this case was CRL and not Unilever as a group. Where an employer is part of a group of companies, when assessing the relevance of the size and nature of the employer's undertaking, the benefit of the patents to the group should be compared with the benefits derived from patents arising out of the employer's work. So other patents from CRL, how they fared in comparison to these Shanks patents. The Supreme Court therefore found that the UK IPO had erred in principle in assessing outstanding benefit. It had wrongly considered that CRL's undertaking was the whole of Unilever's business. Further, the UK IPO had placed too much emphasis on the turnover and profits generated by Unilever. These figures are not directly attributable to Unilever's patent portfolio and can be influenced by other elements of the business and marketing and other such activities. The Supreme Court noted that the size and success of Unilever's business did not play any part in securing the benefit that it had enjoyed from the Shanks patents. The benefit had come from licensing and sale of the patent rights and not from the manufacturing and sales capabilities of Unilever. Given that the rewards Unilever enjoyed were substantial and generated at no real risk to the company, the benefit of the Shanks patents stood out from other patents and was therefore said to be outstanding. The benefit was not a result of any exercise of Unilever's business capabilities, nor did it arise by the virtue of leverage exerted by Unilever. For these reasons, as I said, the Supreme Court held the Shanks patents were of outstanding benefit, and Professor Shanks was entitled to compensation. Just a little bit on the fair share now. There are several factors in Section 41 of the Patents Act which need to be assessed when considering a fair share, and the Supreme Court followed the approach of the UK IPO when considering fair share. The UK IPO had said that a fair share here would be about 5%. Mr. Justice Arnold had reduced that to 3% on appeal to the High Court, and Professor Shanks himself had suggested that a fair share should be somewhere in the region to 10 to 20%. The Supreme Court, looking at the factors, agreed with the hearing officer and said a fair share was 5%. It said also that you should take into account the time value of money, and on that basis, and taking the 5% fair share, Professor Shanks would be left with around £2 million to take away. Why is this case important? The decision is only the second successful case of compensation being awarded under Section 40 of the Patents Act, and therefore it has attracted considerable attention. Companies can no longer say that they're too big to pay. The overall turnover of the company is not necessarily the viewpoint that should be taken when considering the benefit that's obtained. As I said, the key issue here on which the Supreme Court overturned all instances below was the question of whether the patent was outstanding benefit to the employer, here being the immediate employer and not the wider corporate group. Lord Kitchen also opined on how benefit may be found more generally within a company, noting that it may derive from a higher than expected income, a risk-free income, an extraordinarily high rate of return, or even in a pure opportunity, either to develop a new line of business or to engage in any unforeseen licensing activity. With the bar seemingly lowered, employer inventors could now be more able to make claims under this section. It no longer seems that you need to have such a big outstanding benefit as was previously seen in the case of Kelly and GE Healthcare to enable a claim for compensation to be made. From a practical perspective, whether we will see additional claims following this case from Shanks and Unilever is yet to be seen. It may be that companies change policies internally to give additional compensation to employees at the point the invention is made, or at some other point. But that's something we will wait to see. But it was an interesting decision and one we decided to include as number 1 in our top 10.
Thank you, Katie. And thank you to all our listeners for this presentation. We hope you enjoyed it. I would encourage you to provide feedback by email to the addresses listed, and also to send us any questions you may have. This has been a new venture for us, presenting the Patent Review of the Year by webinar. We hope that if you like it and you feel it's worked, we will do it again in future. Thank you for watching.